Welcome back, everyone, to our third panel. During this session, we're having presentations by Eric Posner and Jack Goldsmith, and then Anu Bradford, and finally, Mary Ellen O'Connell. Also, to the extent there was perhaps any confusion created by the title on the program, which was The Limits of International Law and the Social Science Approach, I should note that that was, I think, merely a heading or a grouping to organize people in some way, and not not meant to suggest what Professors Bradford and O'Connell are going to actually be discussing. Now, that said, first up, Eric and Jack. Eric teaches here at the University of Chicago Law School, and Jack Goldsmith is at Harvard Law School. All right, you guys are up.
Thanks, Adam, and thank you to Jared and Nima and the other CJIL people who put together this conference, which I'm enjoying a great deal. So Jack and I are going to talk a little bit about the conception of our book, The Limits of International Law. It's closely connected with the topic of the initial paper about the role of social science in international law. I noticed, by the way, that there are a lot of my antitrust students in the audience, and they might be wondering what I'm doing at a conference on international law. And the answer is that before I got interested in antitrust law about 20 years ago, I got interested in international law. That was about 50 years ago when I first met Jack at the University of Chicago in the 1990s. And Jack actually got me interested in the topic, and so we collaborated on a bunch of papers which culminated in our book, The Limits of International Law, which was published in 2005. And I've done some other stuff since then as well. Limits was an attempt to apply rational choice theory or law and economics to international law. And the book had quite a reception. There was a lot of people wrote reviews of it, and they were almost unanimously negative. There was a lot of criticism of our book, and we expected criticism, and in fact tried to anticipate a lot of it in the book itself. But still, it was quite an experience. And so there were a bunch of criticisms, one of which was that we argued that international law is not law. And we knew people would accuse us of arguing that international law is not law, so we made sure to say on the first page of the book in the second sentence that that's not our view. A lot of people also said that we argued that states never comply with international law, that international law is a kind of a fiction, and compliance with international law is just a kind of epiphenomenon. States might do it sort of by accident, but not because they have any interest in complying with international law. And that wasn't our view either. We argued that states comply with international law when it is instrumentally rational for them to do so. Let's see, how am I gonna, there we go. So why is it? So why was there so much kind of negative response to this book that didn't really, sort of engage with our argument, although of course some of the responses did. So here's some hypotheses in the spirit of social science. The first is that the book was poorly written. Unfortunately, n equals 1, so it's kind of hard to test that hypothesis, but I'm going to stipulate that it was not poorly written. Another possible theory, which Jack and I indulged, was that our critics haven't really read the book very carefully, so of course they didn't understand it, but that's not fair, obviously. A third hypothesis is that our critics approached the book with very strong priors about what we were trying to accomplish, and I think there is a little bit of that. But that's also not a full explanation of the hostile reaction to the book. Fourth hypothesis is that our critics needed a foil. In other words, they needed something to attack so as to motivate their own arguments. And I think that may have been the case for a few people whose names I will not disclose. But I actually think that the reality is different, and nicely it connects to a theme of this conference, going back to the first paper, which is the relationship between social science approaches to international law and skepticism. And I think what was going on here, and I'm sorry about the small print, but that was deliberate as well, as I'll explain. What was going on here is that what I think the critics understood was that this was a highly skeptical book about international law. And the critics, most of whom were, or maybe all of whom were international law professors, did not agree with that skepticism. And while I think Jack and I didn't really intend the book to be just an argument that we should be skeptical about international law, there was that theme in it, which I think we thought our approach led to a certain amount of skepticism about claims that have been made about international law. Although, as I would argue, not about international law itself, correctly understood. So what I call these 16 skepticisms in the book, these were the number of skepticisms that I could think up, but I'm sure there are more. So one is the extent to which states are actually interested in binding themselves to international law. So back when we first started writing in the 1990s, that was the high point of excitement and enthusiasm about international law over the last 50 years, or really since maybe even World War II. And so a lot of international law scholars were making very ambitious arguments about what international law could accomplish. And not just international law scholars, but politicians as well. And one of the things that we thought that, one of our assumptions was that states were basically, they were interested in advancing certain preferences for wealth or security or what have you, but they were less interested in, making the world a better place in the general sense, which is what the scholars were focused on. A second skepticism was the extent to which states are compelled to comply with international law, given that there's no typical centralized enforcer as there is for domestic law in advanced countries. So we very strongly took the position that you cannot just assume that states will comply with their treaties based on the fact that they entered into those treaties, or with customary international law for that matter, that they would only comply if they had a reason to, which also meant that they would violate international law if they had a reason to violate international law. Now, I don't think international law scholars never denied that states violated international law. Obviously, that's happened many times. But I do believe that in the literature of the time, violations of international law were regarded as anomalous and unfortunate rather than simply states pursuing their rational self-interest. A third source of skepticism is the empirical prevalence of compliance with international law. And so there's this famous quote from a highly regarded international law scholar named Louis Henkin, which was to the effect of, I don't remember, most states comply with, or all states comply with most of international law most of the time. We thought that reflected a kind of complacency about international law that was prevalent in the literature, and that in fact it's an open question how much states comply with international law. And in fact, the degree of compliance is a lot more complicated than it might seem. Okay, I'm not going to go through all of these things. I'm more trying to illustrate the possible reason for the negative reaction to the book. But just a few of these things I'll pick out in the interest of time. Sovereign equality, we were skeptical about the notion of sovereign equality, which is central to modern thinking about international law. We believe that more powerful states, more influence under international law, are more likely to violate international law. International law was more likely to reflect their interests than in the cases of weak states. We were skeptical of the notion of constitutional norms in international law, which was a big topic back in the 1990s, the idea that human rights norms and other norms bind states even if they reject them. We were skeptical about the degree to which vague international obligations could have binding effect. It's true that they can, but nothing like they do in domestic law, where you have courts and regulators who refine vague laws and interpret them in the spirit of the law rather than in a narrow way. Okay, we were also one of the frustrating things about the reception to the book was that we made a number of specific claims that we hoped people would address. Like we made some claims about the difference between multilateral treaties and bilateral treaties, arguing that multilateral treaties were more vulnerable to violation than bilateral treaties. This was also in tension with some views in international law in the 1990s and later that multilateral treaties really were much more law-like than bilateral treaties, which were more like contracts between states. We were skeptical both of American exceptionalism and cosmopolitanism. So the American exceptionalist view is that America has some special role to play in developing and managing and enforcing international law. And the cosmopolitan view is that when America does that, it does that in the interest of everybody, because everybody around the world is of equal moral value. We don't take a position on whether we didn't take a position on whether everyone around the world is of equal moral value. I think they are, but I don't think we didn't think that there was any reason that that would be reflected in the international legal policy of the United States. We were also skeptical about Whig histories of international law, and especially human rights law. Back in the 1990s, there was a kind of a standard history of international human rights law, which was one of progression. In more recent years, that view has been attacked by professional historians like Samuel Moyn, but at the time, it was a very common view. Okay, so that gives you a sense of our skepticism. And so we're going to, acknowledge that our critics were at least partly right, that we were at the time and continue to be skeptics in a methodological sense. That is to say, we don't think we should take it for granted or assume that international law is particularly powerful or it's particularly good. Those are empirical questions, and theory can help you organize your thoughts about those questions and come up with hypotheses that can be tested. Okay, so 2 points then is that, what is the legacy of limits, if any? And I should say, I'm not making any strong claims about limits having causal impact on subsequent scholarship. It's hard to make claims like that. It may well have just been part of a wave of new approaches to international law. But one thing that's interesting is that my sense is that theory in international law scholarship has died. There was a lot more theoretical work 20 years ago than there is now. And I'm not sure that, we can take the blame for that or the credit for that, as the case might be, because something very similar is happening in legal scholarship generally. There's an enormous, and I think good, turn to empirical work throughout legal scholarship. But there has been an enormous amount of empirical work. And let me just say, this is my last slide, a couple words about the empirical work. So Jack was actually pressing me on this. I've been a little bit involved in the empirical work. I've co-authored a bit with Adam and some other people. I think the empirical work has been really good. I think Jack is a little bit more skeptical, but in any event, it doesn't, the empirical work hasn't answered any basic questions of the sort that we raised in the limits of international law, but it has actually deepened our knowledge of how international law works. And so there's been, dozens, if not hundreds, of empirical papers in the last 20 years. So it's hard to summarize, but this is how I would try to summarize it. One thing the empirical scholarship does is that, of course, states do comply with many treaties, not something we ever denied, but the extent of compliance varies a lot and can often be traced to features of the states, in question, like what type of political systems, what kind of interests they have, that sort of thing, rather than just, international law as such. Of course, the extent of causal impact remains contested. This is a serious problem with empirical scholarship generally. But I think, it's reasonable to think that a lot of these studies show international law having a causal effect on states' behavior. Another smaller set of the empirical literature looks at how states negotiate and agree on various international obligations. There's this very interesting smallish literature about multilateral treaties and how states use reservations to narrow their obligations, and that too seems to reflect, maybe not surprisingly, the rational behavior of states that seek to protect their interests. Another finding, which is interesting, I just was looking at another paper that just came out by Eric Votan and Larry Helfer. International organizations frequently display biases that can be predicted from the interests of their member states. Now, for domestic law, that doesn't surprise us. There's an absolutely gigantic literature on the Supreme Court and the other domestic courts in the United States showing the influence of personal factors and ideology on case outcomes. So people have applied these methods to international organizations and found similar sorts of effects. Something that is perhaps more obvious from developments over the last 20 years that we all read about in the newspapers than in the scholarship itself is that quite obviously shocks to the status quo can change the state's interest in complying with international law and lead to compliance going up or going down. You see this with human rights treaties and more recently with the trade treaties. And then I would add that the multilateral treaties and organizations seem to be especially vulnerable to these shocks. So these shocks have, when we think about the impacts over the last several years of, pandemic and financial crisis and conflict and so forth, we see them particularly in the areas of human rights, trade, and security law, which are heavily multilateral. And we see it less in things like, extradition treaties and so forth, which are more bilateral. So with that, I will stop, and I look forward to hearing what other people have to say.
All right, great. Thanks, Eric. So our next presenter is Anu Bradford, who was previously here at the University of Chicago and is now at Columbia Law School.
Great, thank you, Adam. And special thanks to Jared and Nima for putting this together, and obviously all my Chicago colleagues. I was trained there, so I learned from the best, and something that I am grateful for every day. So good to be back. So I guess I will respond less directly to the limits of international law and maybe start off my comments from the paper that Adam and Tom and Daniel circulated on the social science approach to international law, and maybe make just a couple of references to the book that Eric and Jack wrote. So if the first conversation was now about limits of international law, if we talk a little bit about the limits of social science as an approach, and that is something that is in the end of the paper that was circulated. And Adam and Tom and Daniel in particular highlight two limits that we should be conscious of. And one is the methods itself, how data is not self-generating, and how we all know that inference is particularly hard when we are studying with cross-national data set, a multifaceted world that is rapidly changing. So I want to say a few words about that. And then talk a little bit about the relevance of social science method in studying this changing world and in the presence of uncertainty. So about the methods themselves, I think we do need to indeed take the criticism of the methods very seriously, but not to the extent that the methods themselves start driving the research agenda and the questions we ask. So if there is a legacy to the limits of international law book, to me, it is the legacy that we need to ask big questions that generate a big debate, and the field is better off for that. So what has happened often, for instance, I think in economics, there is a criticism that we have economists that are now designing studies around instruments and sometimes lose sight on the questions that matter the most. When your audience is referees and journal editors, you do end up then looking to what you can test, how perfectly can you get to inference, for instance? And that leads to the kind of research agenda that may not advance the field the most. So I do want to have a caveat there that, for instance, now when we are going through the pandemic, we should be designing some studies around the natural experiment that is unfolding. We should be asking what is the kind of data that we should be collecting in order to gain some insights from this moment. But in general, I'm inclined to take the view that we are better off asking more important questions that matter, even if the methods with which we can tackle them may fall short of what would be ideal in the perfect world of social science. So if we accept that premise then, that our methods may be vulnerable to criticism, but we at least leverage them towards the debates that matter, I think we need to accept that social science is the kind of discipline where the perfect cannot be the enemy of the good. We do still carry out some cross-national time series analysis, even if we are not exactly sure how extensive claims we can make. And I think that is less problematic if we are very clear in stating the assumptions, the limitations. We are cautious about making claims about external validity of our studies, and generally just become more self-aware as scholars deploying those methods. I'm also particularly encouraged by the kind of empirical work that has been done on international law that relies on mixed methods, that we do see studies that do carry out at the same time some cross-country regressions, natural experiments, survey methods, mixed quantitative and qualitative work. I think often then we can be more confident with the kind of findings that those methods lead us to. And in general, I think there's a great advantage with this empirical turn is that we generate the data. And to the extent we are sharing that data, we are not limited by what an individual researcher can do with that data. Not only can we replicate those studies, but we can have others build on the work that has been done. And sometimes some of the most successful studies are those where we are deploying data that was generated to answer very different questions. Then we do not need to be as worried about what was the bias that was in the mind of the researcher that was coding the data. So a few words on the relevance of social science method for the studying the world that is constantly changing. And there, the concern is not so much that it is our obsession with methods that is driving us towards narrow questions, but that the data we deploy and the assumptions that we make reflect the world that is no longer the one that we are living or that we should be studying. And there, I guess my question more than my answer is that we would reflect on how fundamentally have the assumptions about the world changed. So if Jack and Eric were writing the book today, are you studying a very different world? Are the state's preferences different? Are the constraints that they are facing when pursuing their interests very different? So we might not be able to today group the countries into developed and developing the same way. The line between what is an authoritarian democratic state is no longer as clear. Should we not think about path dependence anymore as central to our study of international institutions? And some of the problems that we are witnessing today. So for instance, if we think about the turn to protectionism and this rise in populist nativist sentiments, is this really something new? And would not the research of past periods of protectionism anymore be relevant for studying the key drivers of that turn in today's world? So in many ways, I would take comfort in social science methods in studying the world that is complex and uncertain, in that the social science method forces us to be very clear about the assumptions that we make about that world. It forces us to reduce the complexity into more simple variables, and again, be very explicit as to what we think are the key variables that are doing that work. So in that sense, I think it can be a more complicated world to study, but a world to which we are particularly blessed if we use the kind of methods that force us to be very cautious and self-conscious. So let me maybe end with the comments on whether social science is best deployed to study the past, the present, or then to predict the future. And I was wondering, often the economists were, for instance, scolded for not foreseeing the financial crisis. The political scientists were told that you did not predict the Brexit or then the rise to the power by President Trump. So what have we missed as international legal scholars? And it does take me back to the limits of international law. That maybe that shows that international law scholarship can have predictive power. Maybe you were seeing the unraveling of some of the fundamentals of international cooperation that we have been witnessing as of late. And I am curious if the response to the limits of international law would be different today than it was back when you wrote the book. So let me maybe end with those comments and then turn it over. I guess it's Mary next.
All right, great. And our third and final speaker for the panel is Mary Ellen O'Connell from Notre Dame Law School.
And I was also at the University of Chicago. It was a wonderful time to be there. I had a great debate with Eric Posner, and we had had other debates before, and we could have had one today if I'd been prepared to know that we were going to be together on this panel. But in fact, serendipitously, my remarks, I think, follow really well from those you gave, Eric, in consultation with Jack, and from Anu. I think Eric's quite right that after the limits of international law, we saw a decline in attention to theory and a turn to more empirical work. But I don't see that as a positive. I see it as leading to some of the problems that we're confronting right now, some of the problems that Anu just alluded to. And I'm going to agree with Anu that we have to ask big questions at this point in history. But let me push us all further to ask much bigger questions than the ones that can be captured or really adequately analyzed through social science methodology. I want to start my remarks proper with a clarification of what law even is. It is not science, despite Oppenheim. It's not even social science. Law is the concrete expression of transcendent norms. Law is best characterized along with those human endeavors associated with the humanities: art, music, literature, religion, theology, philosophy. These are the areas of intellectual pursuit invented by people. So is law. Indeed, anthropologists, philosophers, and historians tell us that law is a social phenomenon, a complex, intricate aspect of human culture. But like religion, it is a normative social practice for guiding human behavior, giving rise to reasons for action. It should be compared with other normative domains. Indeed, law's intelligibility depends on other normative domains, and these in turn on law. I don't doubt for a minute, I've seen it, that social science can add to our knowledge about international law. But it has to add to that knowledge recognizing that law is on the arts side of the arts and sciences divide. It's essential to remember that social science is an adjunct to this field. It cannot tell us what law is or even what its normative content should be, the ought of Tom Ginsburg's opening remarks versus the is. Our approach to the ought questions has been and remains dependent on humanistic approaches. All of us working in law need a basic understanding of humanism and the knowledge we gain from humanistic approaches before we can really fully benefit from the additional information provided by those trained in social science methodology. Legal scholars employing social science are like historians who also use social science in contrast to historic humanistic approaches. In a famous report on history of social science, the authors, proponents of social science, wrote that students of history as social science will always need training in all aspects of the discipline. If anything, the growing sophistication of social scientific techniques makes it all the more important for practitioners of these techniques to know and appreciate the humanistic approach to historical knowledge. We cannot afford to gain a world of numbers and models only to lose our historical souls in the process. Let me provide a brief illustration of providing numbers in the absence of, shall we say, our legal souls. In The Internationalists, Yale law professors Ona Hathaway and Scott Shapiro present survey data on conquest through military force. They show a clear decline in territorial acquisition, which has been occurring for decades, but they link it to one treaty, the 1928 Treaty on the Renunciation of War. Their data about declining territorial acquisition is important, but it's ultimately unpersuasive that it's related to the 1928 treaty, at least that alone. Hathaway and Shapiro assert before 1928, every state accepted that war wasn't a departure from civilized politics. It was civilized politics. But this statement overlooks the just war doctrine, which has been part of international law from international law's earliest days. The just war doctrine generally prohibits the resort to force except in limited cases. When the state system arose in 1648, this prohibition was in place, along with additional natural law restraints on resort to force, including, most importantly, the general principles of necessity and proportionality. With the scientific revolution, international law scholars shifted their attention away from the sources and natural law to material evidence of law. And that led to a preference for treaties and rules of customary international law over general principles and peremptory norms of natural law, such as the prohibition on the use of force. The absence of natural law and the just war doctrine from international law in general, it might be understandable, but it's not understandable in the book, The Internationalists, because the authors focus on the truly great natural law scholar of all time, Hugo Groceus. He was a 17th century jurist, theologian, and diplomat, and he's commonly described and credited with being the father of international law. Well, Hathaway and Shapiro dismiss him and his great work. They prefer to focus on a legal brief he wrote for money, and in that he underplays the rule against the use of force. But in his seminal work, The Law of War and Peace, he set out as the core principle of all the international order that he was seeking to educate the community about was the prohibition on the use of force. So his blueprint, his core norm, is 300 years before the Kellogg-Briand Pact of 1928. In an article published in 1946, Hirsch-Lauterpacht extolled Groceus as the quintessential proponent of right over might. And so did another hero in the Hathaway and Shapiro book, the legal philosopher Hans Kelsen. Kelsen wrote in his General Theory of Law and the State that the just war doctrine persisted in international law through the time of the Kellogg-Briand Pact, and credited Augustine, Aquinas, and Groceus as having developed the concept of war being forbidden except in cases of lawful cause. All of these men understood that the peremptory norms of international law, such as the prohibition on the use of force, are not mere treaty principles. They understood that natural law generally includes such principles as necessity and proportionality. Treaty principles can and do change when they are under assault, but peremptory norms do not. Thus, the prohibition on the use of force is durable and has not changed or come into existence because of a treaty or a rule of customary international law. Now, the prohibition on the use of force is a social phenomenon. It can be studied using social science approaches, as Hathaway and Shapiro do, and as Ginsburg, Abebe, and Chilton extol in their paper. But social science cannot explain or impart full understanding of the essence of natural law or a principle of natural law like the prohibition on the use of force. This is not open to social science capture. And I would say that at this historic juncture, it's far more important to renew our deeper, comprehensive understanding of what law is, how to create a new era of respect for law, and how to advance social science, as useful as that is. Law is premised on the fact that human beings are social and seek the simple pleasure of one another's company. Flourishing life in society requires a certain order, not the order that can be created through physical force or acceptance of hierarchical authority, but through the type of order that social acceptance of the idea of law can create. We know this from anthropology and historiography and legal theory, but the content of the idea of law and the knowledge that law is good is known through the insights of humanists and natural law scholars. It is natural law theory that explains, for example, what law is, that is, the concrete expression of transcendent norms. The concrete expression is mostly found in the form of positive law. Natural law also, however, explains why positive law is even binding. It explains the content of transcendent norms expressed in positive law. None of this is accomplished through the study of material evidence alone. It requires natural law method, involving, for example, the legal theorist, judge, or lawmaker observing the natural world, using reasoning capacity while remaining open to inspiration about the conclusions to draw when reasoning about the natural world. It is the method of Groceus and Lauterpacht. Groceus, of course, knew only natural law. He looked for inspiration in reasoning about the natural world in the divine texts of multiple religions and the works of the great philosophers. He discerned the answers to questions about the purpose of human life and life in harmonious society as a good by applying reason to observation of nature and perception of divine will or command. Divine will he learned from the study of holy texts, revelation, and prayer. Of course, with the rise of science and the suppression of natural law theory, transcendent sources of knowledge were lost. It took over 200 years, but by the middle of the 20th century, natural law was so sufficiently suppressed that we really began this decline in theory that Eric has observed. But most people, I think, would still accept that fundamental answers to international law today are still found in natural law theory. We've just inherited them without really understanding them deeply. Those sources have not been replaced, certainly not by social science. We do now, today, have a humanist, secular answer that can replace the old religious sources, theological sources of natural law inspiration. That has been history more recently, but also philosophy. And I've written about one particular area of philosophy that's very rich with transcendent inspiration, aesthetic philosophy. We are witnessing, in fact, an understanding that we have lost too much knowledge of theory. And a renaissance is happening in terms of natural law and people interested in natural law. They're interested once again in why is law good? Why should we seek to understand it and promote it? Why should we study it? Why should we care about social science data about it? The introduction to that report on history of social science concluded with a line that I believe applies equally to law. If historiography is art, it cannot and must not be reduced to some kind of routine. And by routine, they mean a sterile social science process. Measuring various limited aspects of law and legal phenomena is useful. Understanding what law is, as well as its normative core, however, is essential.
Great. Okay. Just a reminder, anyone that has questions can either send them to me in the chat or to everyone in the chat, I guess, or to raise hands. The first question that I have is from Mark Pollock from Temple, who's here with us today, sent in a question, which is for Eric and Jack, and specifically about within the book, The Limits of International Law. In addition to making the arguments that Eric went through on the slides, the book also, one of the concluding chapters focuses on whether or not countries have a moral obligation to comply with international law. And at the time of the publication of the book, Ona Hathaway and Ariel Levin-Book wrote a response saying that the focus on the moral obligations that didn't logically flow from the first part of the book, which was the use of the rational choice theory. Do you guys think that's a fair criticism, or that part is the moral obligation to comply with international law is a key piece of your argument or theory?
I'll let Eric talk about that chapter, but its content, since he wrote that chapter. But I would say, I'm not even sure he agrees with what I'm about to say. But that
not.
chapter, sorry?
Probably not.
Yeah, he never does agree with what I have to say. No, I don't believe that chapter or the chapter on cosmopolitan theory followed in any sense from the rational choice center of the book. We were trying to, the book, very broadly conceived, was meant to be a kind of response or attack, or a response maybe is the better word, to standard ways of looking at international law. And in using very simple social science tools to do that, we used rational choice mostly for that. Those last two chapters were designed to get at different aspects of kind of scholarly assumptions that the rational choice models didn't get at. So I would say that they didn't follow at all and are disconnectable from the rational choice parts of the book. Do you agree, Eric?
A little bit. I agree with part of what you're saying. Part of the idea was to clear away the terrain so that we could make our rational choice argument. A lot of people at the time sort of assumed that states have a moral obligation to comply with international law. So we didn't, we or I or whatever, didn't think so. And so that opened up this space to make the argument that states cooperate in order to advance their self-interest. But, I do think there's a difference between the moral obligation to comply with domestic law and international law. If you live in a well-ordered state, a democracy where you can generally assume that the laws reflect some kind of legitimate process and the interests of the public, I do think you have a moral obligation to comply with the law, even if you don't like it or disagree with it in most cases. Although obviously there are exceptions, which might justify civil disobedience. But I think in the case of international law, where the law is the result of deals between different states that are not always very nice to the public, I don't think that moral obligation is well. I don't think there's a moral obligation on the part of states that's presumptive in the sense that it is for individuals. So part of it was to just try to prevent people from using these arguments about the moral obligation to comply with domestic law and then just sort of transfer it to the international plane. Let me also just jump in and answer Anu's question. Yes, I guess I don't want to say we predicted anything, but we were. I do think that that let's call it the skepticism, has been to some extent vindicated by recent events. On the other hand, international law has gone up and down, and it could very much recover and flourish, and we could even have world government in a few months. That's possible. So I don't think that we know enough about how the world works to make confident predictions about what's going to happen in a few years. But I do think, or in any time period, but I do think in the literature at the time, there were a lot of people who were quite confident about their prediction that international human rights law would advance, that the trade law would advance, that there'd be more international institutions, that they'd be more powerful, that states would respect them more, that international criminal justice would be, pursued by the International Criminal Court and other institutions. So that sort of optimism we were skeptical about, and I think we were more right than wrong on that issue.
For what it's worth, in addition to Eric's antitrust students here, there's quite a few of my international law students. And I assigned the first two sections of the book on the rational choice and the theory parts. And we don't get to the moral and cosmopolitan theories at the back end. So there might be people here that weren't even aware that was in there. Now, there's a question for Anu on African national and regional competition agencies, but Mary Ellen, if you wanted to focus on this piece.
Yeah, I just wanted to briefly make the comment that I don't think we should be distinguishing whether there's a moral obligation to comply with international law from moral obligations to comply with law in general. If you think there is a moral obligation to comply with law, which I do, there is no real distinction between why you would comply with the law of Indiana, where I am, or the United States versus international law. Law is part of a particular culture. We have an international community. It has its law. And if you think that law is good for the South Bend community, it's also good for the international community. So I think one of the many misunderstandings about international law in our world today is that there's something qualitatively different about what the core of this law is. Law is the same. It just reflects the community that gave rise to it. So if you think there's a moral obligation to comply with law in other jurisdictions, there definitely is as well for international. And I guess vice versa if you don't think there's any moral obligation.
So we have now a question in the chat for Anu, and the question is about your work on comparative competition law, and specifically what some of the lessons can be for how to use a social science approach to study competition policy in Africa specifically, or perhaps in developing countries more generally. And the question is how to understand the political constatations between the competition law agencies of individual countries and then regional competition agencies and supranational competition laws or obligations or authorities that sit on top of them. All right, I'll let you jump in on.
Terrific, Adam, and I think, Adam, you would be equally well placed to answer this since we've tried to study these regimes for the past several years. So I think it is a very important question. It's something that we get to more indirectly through our large and cross-national studies. So we have coded the competition regimes across Africa, both at the national level, but also at the regional institutional level, and are able to offer some insights which include African countries. And that was something that we were particularly proud of with our data set, that often these studies are limited to develop a world, and the world which has been more accessible to study. So we worked very hard to obtain data from Africa and actually got rather good coverage on some countries. But I do think that exactly the questions that you raise on the political, cultural context, that does get lost in the kind of method that we were deploying. And really to understand how these regimes come into being, why do they look like what they look like? We can see that they are often copied, for instance, from the European Union. We say that it may be partially because, for instance, Francophone African countries have been able to access those templates in French, because the EU has provided a lot of technical assistance, willingly exporting those regimes. The EU has often, when it has signed trade agreements with African countries, included provisions that are modeled according to the EU's own competition provisions. So we have some way of advancing the debate, but really, to get to the questions that you are asking, I would invite and deploy the methods that are more qualitative, that you do these in-depth country case studies, and that would help us all understand much better that what is driving those reforms, why and when they are potentially successful. We are getting to those questions in some of our recent work with Adam and Katarina Linos. We've done some deep case studies. I do not think we have one on Africa. We have some on Latin America and some on Asia, but I think it is a very promising model forward and complements the kind of cross-national work that we have done.
Let me just add one more general thing than Anu's specific answer. So what Anu is discussing and this question is asking about is a large project that Anu started and I joined on trying to measure competition law around the world. I think in general, if there are either scholars or students here that are interested in social science projects on international law, then you can think of social science projects as either being about measurement or identification. Measurement is just counting or figuring out or coding what's in the world, and identification is does X cause Y. I think lawyers have a real advantage on measurement over economists or political scientists because of taking the time to deeply learn things about the institutions and the details and the law and the substance. And I'd encourage people to think of measurement projects like this that they can jump in on. Now, so we don't have any more direct questions, but since I have you guys here, I actually want to ask a question that's perhaps teed up by this exchange that Eric was having with Anu about the future of limits or the implications. So with the start of the Biden administration right now, the WTO is being re-jump-started or claimed to be re-jump-started. We have a new director general that starts on Monday. There's some effort to rejoin some of these international institutions, re-signing the Paris Climate Accord. The question is, are we reversing a trend that we saw since the publication of limits, or is this just all, I don't know, PR, epiphenomenal, something like this? Do you think that there's going to be a new round of deep international cooperation?
I don't know. We'll have to wait and see. I think it's possible. It's possible. I'm skeptical that just a change in administration in the United States alone would be important enough, would be significant enough to change long-term trends that go back way before Trump, including, declining compliance with human rights law. There's been people have been unhappy with the trade regime, the modern trade regime, since its inception in the 1990s. And it just seems that the political institutions have caught up with public opinion, which has also been changing with bad economic times. So I think it would take more than that. But so I don't think our book really predicted anything. I think what it did is it expressed skepticism based on our theory and our sense of the evidence about reining much more optimistic theories. And I think a skeptic should be cautious about making predictions. And actually, let me respond to Mary Ellen's point also while I'm at it, because this is related. Actually, I 50% agree with Mary Ellen. I think there are real limits on what social science can do. And it certainly cannot address questions that are not, about whatever, human behavior in the narrowest sense, watching how people behave, governments or what have you. And I think that one should criticize people who use social science methodologies to make claims that are not actually supported by data. And you can, I actually haven't read the book by Ona Hathaway and Scott Shapiro, but I have read reviews, and you can't using social scientific methods, take today and 100 years ago and notice that their outcomes are different, and then just say that something happened halfway in between is the cause. If the Kellogg-Briand Pact was really just a series of bilateral treaties between lots of different states that was gradually entered into over a long period of time, then it might be possible for someone who uses social science methodology to figure out whether it has causal impact. But unfortunately, that's not how it works. So we're just stuck with limited knowledge about the impact of that treaty. In terms of natural law, I guess you're expressing a view that I don't share, but I do agree with you that if your view is correct, there's even less, less role for social science in elucidating, the meaning and impact of international law. I'm not going to disagree with the implications of your premises.
Thank you, Eric. I think I'm speechless almost. I usually have things I can respond in disagreement, but we're in accord. I think the points you just made are absolutely solid. I'll just make one more shout out for natural law. It is remarkable to me that perhaps growing out of the pandemic and the real confusion that the world seems to be in over our legal obligations, our sense of how we cooperate together to prevent another disaster of this kind is driving people back to first principles, back to understanding. At least I've never seen so much activity. A lot of it's still negative because people don't even know what natural law is anymore, and they tend to be afraid of what they don't know. But there is now a real opening and understanding that our basic knowledge of international law is so deteriorated, it's very hard to explain why people should comply with it, why governments should care about it, why we should make these efforts to study it and promote it. So, thanks.
I would jump in and make one additional comment on what Eric said about the Hathaway and Shapiro book and what we know about the changes into the causes of war and territorial acquisition. I think the point that Eric made is a real general one that's a deep difficulty for scholarship on international law, which is that we have, at least in the 20th century, these two big periods of so much change of international law, which is immediately following World War I and then, World War II, like the creation of the GATT, the UN, the Convention on Genocide, the Refugee Convention, all of these things happening in the late 40s, and then again in the early 90s. And these things happen in a way that's all sort of commingled with each other at the time that the world just changes dramatically. And so when people try to disentangle the causes of the trade regime, the refugee regime, the genocide regime, the laws of war, it's just almost impossible in so many of these cases because we don't have the kind of variation that you would want and the kind of right conditions for social science scholarship. And the kind of conditions that, for instance, Weijia talked about during her presentation on the last panel, where you can find conditional theories where there's variation along those theories. All right, one more question for Mary Ellen from James Gatti, which is, can you please apply your approach prioritizing a humanistic approach to questions relating to the use of force and drone strikes, especially now that the new administration has already launched strikes in Syria?
I spent a large part of the morning commenting on the strikes in Syria for news media, just trying to explain that despite the fact President Biden says that we were somehow using force lawfully under the UN Charter, that, bonus points for at least knowing what the source of the law was. I had my doubts during the Trump administration that they did know Article 51 was the relevant law. Unfortunately, it's just been, I think, Eric mentioned this as well. We've been in this decline. It's not just the Trump administration. We've been in a decades-long decline. I tend to date it from the end of the Cold War and the rise of American exceptionalism and this sense by liberal internationalists that they had a free pass on complying with international law, that they were more enlightened than others and could shape the law for their own agenda, and that was so distinctive, so at odds with what international law really is. This international, universal body of ancient principles that we have grown to meet the needs of the international community, and it really has been a backwards movement for decades. So we have a problem like as we're confronting in the Middle East with from the Bush administration through the Obama administration, using force in Yemen, really helping exacerbate the instability in that country, the ongoing violence, and so until it came to such a crisis point with the amount of the most important international human rights principles violated by Saudi Arabia, which is violating the prohibition on force by intervening in a civil war in the first place, and hundreds of thousands of children starving to death, and the United States has been part of it. That's the crisis point we've come to by not basically understanding or respecting the most important international law. So finally, the Biden administration sees the magnitude of this moral and legal wrong. They decide to withdraw from that conflict. They do a really important thing, sending Robert Malley to be the envoy to Iran, and then they take this retrograde step, showing that the pandemic lessons and the rest have not had their impact, that we international lawyers have not explained fully enough from our humanistic perspective why the prohibition on the use of force restricts and prohibits the air attacks that happened in Syria yesterday. So we've got our work to do. It's on us. As Eric said, we let go of theory. Most of us don't even understand natural law. We couldn't explain what a peremptory norm really is and why it's binding and why it doesn't change with state practice. All of this lack of knowledge has added into it. So we are really, if we want to if we want to predict a world, if we want to grow toward the world that we can envision, even if we can't predict it now, as Eric and Anu described, we can work toward that by reinstilling basic understanding. It's great to have the social science method, but it doesn't matter if it's measuring things that are not really international law. So that's my final word, is that we really have an opportunity in the chaos of the pandemic to re-educate ourselves and the international community about the most important common bond that we have, international law. And hopefully the children of the future will have a less chaotic, less violent world, one in which climate change is held in check.
Thanks everyone for the comments and from this panel.